case. The case before the court is the case concerning certain activities within the Malachi Gap. The parties are applicant Amelia versus the respondent, the Republic of Lithuania. The applicant and the respondent are each allocated 45 minutes to present their evidence. Thank you very much. I would like to welcome first the parties to this case, the applicant and the respondents team, and I would like to welcome everyone who is here today. So let us, without further ado, resort to our business, and the floor is over to the team of the applicant. Oh, the seat is over there. Sorry, but in the courtroom where I'm presiding over, the applicant sits over there, so sorry.
Madam President, Your Excellencies, my name is Lena Borislavova, and I appear on behalf of the applicant in this case, the state of Amalia. For the next 23 minutes, I will address the first two submissions and prove that Britannia has violated its obligations with respect to the Excelsior Island project, and that there is a direct causal link between these violations and the damages caused to the applicant in this case, which is therefore entitled to seek compensation. On our second claim, Your Excellencies, we will prove that Amalia has exclusive ownership over the wreck of the Cargast and all of its cargo, and that the sending of patrol vessels by the respondent violated international law. I will then yield the floor to my co-agent, Mr. Evgeny Minchev, who will speak for 20 minutes and present our last two submissions. We reserve 2 minutes for rebuttal. Madam President, may it please the Court. Your Excellencies, regarding our first submission, we will prove that Britannia has breached its international obligations, allowing for harmful dredging to be conducted in the Malachi Gap area, and that therefore the breaches that have been caused to the applicant have to be compensated. Turning to our first point, we submit that the dredging in the Malachi Gap was unlawful. Firstly, because Britannia was obliged not to allow dredging without the prior approval of the competent Amalian authorities, and further, because Britannia violated its obligations to prevent transboundary harm under customary international law. Turning to our first point, namely the first breach of Britannia, the granting of a permit without prior approval, we would like to draw the attention of the Court to the Malachi Gap Treaty concluded between the parties in 1992. Under this treaty, Britannia acknowledged the unique interests of Amalia regarding the fishing activities in the Malachi Gap area, and under its Article 12, letter A, Amalia was granted the exclusive competence to regulate any activities that pose risks to the waters in the Malachi Gap area.
So that also applies to the exclusive economic zone for Britannia?
Your Excellency, we invoke in our oral pleadings only the violations and omissions of the respondent with regards to the dredging conducted in the Malachi Gap area. However, we also do not deem that the respondent has complied with its obligation to pay due regards to the interests of Amalia in its exclusive and uncontested EEZ when deciding to locate and to conduct such large project.
Well, just to clarify, where did the dredging take place? In the Malachi Gap or in the EEZ?
Your Excellency, as for the facts of the compromise, the dredging was conducted entirely in the Malachi Gap, and moreover, it was conducted in geomorphologically not unstable regions, which is the reason why it was placed, the respondent was placed under the obligation to to ensure compliance with the licensing regime of Amalia under the application of the Malachi Gap Treaty. And in this regard, we submit that Britannia, by not ensuring such compliance, violated actually its obligations. Secondly, as the dredging is indeed such a dangerous activity that poses risks to the environment and to the population of the Malachi Gap, we submit that Britannia is further obliged to take appropriate measures for prevention of environmental damages with transboundary character.
Excuse me. You say that dredging is dangerous. Is dredging dangerous in every circumstance?
No, Your Excellency. However, we submit that this particular dredging is dangerous for the following two propositions. Firstly, because of its immense size and the fact that it is the largest project engaging dredging activities in the world. For comparison, the second largest was conducted in Dubai in year 2013, and it consisted in less than 500,000 of cubic meters of rock and sand to be reclaimed, thus being 4 times smaller than the one to be conducted in the Malachi Gap area. And although it was 4 times smaller, there was an environmental impact assessment conducted with regards to the environmental impacts on the marine environment in this area. And we asked the court also to consider the fact that the dredging is also dangerous due to the presence of gas hydrates in the region and on the foot of Sirius Plateau. And as it was stated and provided in the ILSO report from 2008, exactly because of the presence of these gas hydrates, it was...
How do we treat this report? How do we actually know that it's a reliable document for this court?
Your Excellency, we asked the court to ascribe great evidential value of this report because of the fact that it was conducted by a non-governmental body.
What have been done before by this court?
Your Excellency, for example, in the Bosnian genocide case, in paragraph 227, the court stated that reports from official or independent bodies should be ascribed great weight, taken in consideration the source of these reports, the process by which they have been generated, and also the quality of the persons who conducted those reports.
What's independent? Can we actually say that the assessment made in Mauritania was not independent?
Your Excellency, indeed, the environmental impact assessment and the report was conducted on behalf of the applicant in this case. However, we submit that this fact is without prejudice to the reliance and the evidential value of this report. As already stated, it was conducted by prominent scholars from all over the world, which assessed exactly which had the competences with regards to marine environment and the possible negative impacts. And therefore, we submit that this is a reliable source and place the respondent under the obligation to take into consideration the information there and to take appropriate measures for prevention.
But
However,
where does this particular rule that the respondent had this obligation stem from?
Your Excellency, the obligation for taking measures of prevention of transboundary harm is proclaimed for customary international law in the ruling of this court in the Pope News case, and also in
Does
the...
this court proclaim customary international rules in its judgments? How does it work?
Your Excellency, the court stated that it is general obligation of states to take such appropriate measures of prevention, assessing the fact that there have been settled state practice and opinion juris with regards to the need to conduct environmental impact assessment and measures of prevention. And this is also in accordance with Article 38 of this court statute concerning which are the sources of international law to be applied to such disputes between states. And
just in this regard, could circumstantial evidence be used before this court and under what conditions?
Your Excellency, we submit that the court has the freedom to assess different types of evidence and circumstances presented before it, and it is the discretion of the court to decide whether to take them into consideration or not.
Could also this court use domestic jurisprudence in its findings?
Madam President, we submit that the court has this right, and particularly when deciding and assessing which are the applicable rules of law, as this court has done in the jurisdictional immunities case in the year 2012, where it assessed in paragraph 55 that the decisions of national bodies, of national legislation bodies, should be taken into consideration and should have significance as to which are the applicable rules under customary international law.
But as evidence or as facts?
Your Excellency, we submit that the court can assess national legislation either as jurisprudence as evidence for state practice.
Sorry, going back to what you were saying, you seem to present 2 points to us. First, the Malachi Gap Treaty, and secondly, this idea of transboundary damage. Have you moved on to your second point now? Because everything with regards to EIA assessment seems to be about the second submission.
Your Excellency, our second point is that, namely, it was that that Ritania has not implemented appropriate measures for prevention, and our next argument on this is that it could not even take such measures which are appropriate because of the fact that it did not have the information necessary to address in appropriate manner the risks associated with the dredging, as it did not inform itself of the risks which the dredging involved, and moreover it disregarded the same ILSA report from the year 2008.
You are establishing that there are potentially some shortcomings in assessment, but in none of this am I seeing a direct link of attribution between the actual dredging and the responsibilities incurred for the state.
Your Excellency, addressing the causal link between the wrongful conduct of Ritania, its omissions and wrongdoings, and the economic losses of Amalea, we would like to point the attention of the court to paragraph 28 of the compromise, where it is stated that the landslide which occurred and caused the damages to the applicant was by all accounts a direct consequence from the dredging conducted on the Sirius Plateau, for which the ILSA report alarmed the
Who did the
respondent.
dredging, is my question.
Can you repeat your question?
Who was it who did the dredging?
Your Excellency, it was from the facts of the compromise, it could be inferred that this was the private company. However, it was the obligation directly incumbent upon the respondent to take all measures in order to ensure compliance and measures of prevention. And as the respondent granted a permit, in this way it authorized and allowed for this private company to engage in harmful dredging, although it was not assessed rightfully, and although this was not in compliance with...
What does the permit say? It says they can dredge, correct?
Your Excellency, in the compromise, it is stated that they granted the permit for the construction of the Excelsior
So
Island.
they don't say whether dynamite could be used, whether a nuclear bomb could be used, or whether it could be chipped away with a chisel. The actual damage is caused by the way that dredging happened, potentially, not by the action of dredging itself. And that, as far as I can see, Ritania has done nothing to authorize a permit for the type of dredging that was carried out.
Your Excellencies, in the compromise, it is stated in paragraph 23 that the dredging did not address, that the environmental impact assessment, which the Ritanian authorities did not address only the impacts on the dredging on the waters in the Malachi Gap area. However, this allows the reasonable assertion that all other aspects which were involved in, with the dredging and associated with its conduct as part of the construction of the Excelsior Island project were reviewed by all competent Ritanian authorities before granting this permit. Therefore, we rely on this fact that Ritania has actually conducted an omission allowing and wrongful act allowing for such dredging to be conducted, and disengage its responsibility.
Omission. Their responsibility for a wrongful act is as a result of an omission. Do you see the slight odd factor there, that you're saying it's an act that they're responsible for, but their act is an omission?
Your Excellency, let me clarify on this question. We submit to the court that the granting of a permit was a wrongful act, active act, and the subsequent behavior of the respondent, which did not engage in any activity as to prevent or mitigate the damages resulting from an activity which was conducted under its jurisdiction. This is an omission on the part of the respondent, which also violates international law and engages its responsibility. And now I would like to turn to our second claim, namely that namely the ownership issues presented before this court, And as our esteemed opponents do not challenge the ownership of Amalia over the wreck of the Kargas in their written memorials, we won't address this issue in our oral pleadings. We will present only our arguments regarding the title over the cargo, which rests with the applicant in this case, based on the following proposition, namely, that Amalia had acquired the title over them at the time of the siege of Helios, and that Amalia is under no obligation to return those objects back to Britannia. As to the question of the sending of patrol vessels, we submit that this was a violation of the prohibition for the threat of use of force which Britannia conducted through this patrolling activity. On our first argument, namely the title of Amalia over the artifacts of Britannian origin, it is the view of the applicant that the issue of ownership over the cargo is to be traced back in history at the time when the items in question were acquired during the siege of Helios. This is in accordance with the intertemporal rule provided for in the Island of Palmas case, and which stipulates that the applicable law for the act creative of a right is the law in force at the time the right arises. Thus, we ask the court to apply the 16th century rules of law. According,
Could you explain them?
of course, Your Excellencies, under these rules, prizes acquired during military operations by private heirs were considered public property. This was stated by Hugo Grotius in his commentaries on the law of prize and booty, where he proclaimed that spoils of war are public property, and it's also supported by the practice of private heirs dating back in this century. Therefore,
Sorry, that's two entirely different concepts. Spoils of war and actions of privateer are not the same thing.
Your Excellency, in this regard, the applicant contends that private heirs were used in order to engage in such military operations against belligerent parties of the state which commissioned them. And it is our submission that analyzing the practice of letters of marque and the conduct of privateers, they were deemed as part of the regular navy forces of the state, and therefore had the right to conduct such operations like Baltic verdigris did.
What was the purpose of hiring privateers then?
Your Excellency, privateers were sent in order to attack vessels.
Why wouldn't the state just send the navy forces? Why would they need to actually employ private persons?
Your Excellency, one of the reasons for this is the fact that this was an easy way to ensure greater military presence and to combat enemy states. And therefore, it was used also by the Queen Elizabeth I to authorize such private persons to attack their belligerent states, cities, and their foreign vessels.
Was there a concept of piracy in the 16th century?
Your Excellency, indeed, at this period there was also piracy present. However, if we analyze the practice of states, and again, for example, the one of the Queen Elizabeth, the authorization and the perceived legality of the actions that are those is the fact which forms the distinction between piracy and privateers. And we would like to point the attention of the court that the actions of Baltic verdigris were not condemned by the King of Amalia, and this strongly indicates that he acted with the allowance and within the scope of the letter of marque granted to him.
What is the nature of the artifacts discovered in the Kargas? Are they cultural heritage?
Your Excellency, we submit that they satisfies the requirements for cultural heritage. However, we would like to address...
What is the authority?
In this regard, we rely on the definition provided, for example, in the UNESCO Convention, which represents the general understanding for what is underwater cultural heritage. The requirements are namely that there is at least 100 years threshold for this treasure to have been lying on the seabed.
Does this convention regulate ownership rights?
No, Madam President, it is expressly stated that this Convention does not regulate ownership rights. Therefore, we ask the court to apply customary international law as to the rights of the applicant over those artifacts. And now we would like to address the contention of the respondent in their written memorials on page 13 that the objects should be returned to the respondent as form of a restitution.
Before you go there, I'm going to go back to my question with regards to this idea that they are privateers acting in a war. The reason I say it's two different things is because for there to be a war, there would need to be establishment that there is a situation of war. Where do you get from the fact of the compromise that there was a state of war between the two states?
Your Excellency, 2 points on this. Indeed, in the facts of the compromise, there is nowhere explicitly stated that both states were not in situation of war. However, this could be inferred.
That's a double negative. It doesn't say that there is no war, so there must be a war. That's a fallacy.
Pardon my formulation of this contention. We merely submit that the situation of war between the states is to be inferred from the facts because of the following three. First, the mere fact that the letter of marque has been issued, which provides for such lawful military activities.
Which brings me to my second question. The idea of using privateers is exactly to avoid war. That's why Elizabeth I used them so extensively, to avoid a fight with the Spanish Armada. Because they didn't want to declare war on Spain, but they wanted to destroy their ships.
Your Excellency, in this regard, we submit that Queen Elizabeth adopted actually a rather flexible approach with regards to the relationships with Spain and its armada, and it was exactly based on the analysis of Queen Elizabeth's actions that the authorization and the perceived legality of the actions by the state which sent those privateers was the point of distinction between them acting as piracy or on behalf of the state.
But are you aware of any examples where like actions of privateers would actually give rise to a war, a situation of war between two countries?
2 points on this, Your Excellency. First, we would like to invoke the law of war and peace by Hugo Grotius, in which Chapter 5 it claimed that persons are regarded as instruments at king's disposal to which he could declare war, and therefore we submit that in alternative the actions of both degrees could be deemed as a wage of war on behalf of the applicant against the respondent. And again, a strong indication that this was within the letter of marque is the subsequent treatment of both degrees and the fact that he was not condemned by...
We don't have the actual copy of letter of marque. If we go on the basis that there is no war, how would it affect your argumentation?
Your Excellency, if there was no war between the states and the applicant did not have the right to acquire those objects, then the title over them would have not been transferred to the applicant. And in the interest of time, I would like to present our arguments on the legality of the sending of patrol vessels. And namely, we submit that this constitutes a violation of the prohibition for the threat of use of force, as enshrined in Article 2.4 of the UN Charter and confirmed by this court in the Nicaragua case. Furthermore, in its nuclear weapons advisory opinion, the court stated that the prohibition of the threat of use of force is violated if the state signals intention to use force. We submit that threat of use of force is given if a government expresses or implies intent to use force in case of non-compliance with its demands, as stated by the prominent scholar in this regard, Ian Brownlee. And by sending these naval patrol vessels...
Just finish your argument.
In order to prevent the dives of Belize, Britannia expressed such intention to engage in military actions in order to prevent them.
Thank you, Ms. Borislavova. Now we turn to Mr. Minchev. Your approach of the country, please.
Madam President, Your Excellencies, my name is Evgeny Minchev, and it is an honor for me to appear before the International Court of Justice, pleading on behalf of the state of Amalia, applicant in this case. I will speak for the next 20 minutes, and I will address Amalia's third and fourth submissions. Our third submission is that the Amalian Navy had the right to pursue and arrest Oscar Lelus. And our fourth submission is that the Amalian courts had the right to exercise jurisdiction over Luz's acts, and Amalia is under no obligation to return Luz back to Britannia. May it please the court, we now turn to our third submission. Your Excellencies, we submit that Amalia pursued and arrested Oscar de Luz in compliance with international law. First of all, on reasonable suspicions of piracy with respect to Oscar de Luz, and alternatively, due to the right of hot pursuit. Both grounds.
What gives you reasons to believe that there was this perception of privacy? The facts from the case. What gives you reasons to believe that there was piracy on the part of Mr. de Luz?
Madam President, we submit that as per the definition of piracy, as enshrined in Article 15 of the High Seas Convention, there were reasonable grounds to suspect Oscar de Luz was engaged in piratical activities.
Which are?
The Rosekill incident, namely, also the collision with the Icarus, and both these incidents taken in conjunction with his overall behavior,
But
and the fact that
nothing was taken from Rosenhill. So,
what are the elements of piracy exactly?
Your Excellency, the elements of piracy are, first of all, an act of violence committed on the high seas against another ship for private ends. We submit that in this case, there were reasonable grounds to suspect that Oscar de Luz committed an attempted act of piracy, with regards to the Rosekill, and this also attracts enforcement jurisdiction with respect to piracy, as has been the position of the Seychelles Supreme Court in the Intertuna 2 case judgment from 2010, where it has been stated that an interdicting vessel does not infringe international law where it seizes a ship that attempted piracy.
Were the Amalian authorities pursuing the ship of the Luz for the reason of piracy? Do we know it from the company?
Your Excellency, as for the facts of the compromise, it has not been stated explicitly that
what has been stated by the company explicitly? Exactly.
Your Excellency, it has been stated that after receiving the ACPS alert, Captain Haddock directed the Icarus towards.
What did the alert say?
Your Excellency, as stated in paragraph 44 of the compromise and paragraph 12 of the clarifications of the compromise, it was stated that the Daedalus provoked the Rosekill incident, that it was a stolen vessel, and also that it was suspected of being engaged in human trafficking. In view of this alert and of the fact that Oscar de Luz tried to escape the Icarus, we submit that at the time of the pursuit and arrest, there existed reasonable grounds to suspect him of piracy, which evidentiary standard refers to such.
Not in human trafficking.
On our alternative claim, with regards to our right to pursue and arrest Luz, we submit that we had the right of hot pursuit due to infringement of Amalia's immigration laws within the contiguous zone.
Before you go there, you mentioned two acts of violence. One was the Rosekill incident and one was the collision with the Icarus. With regards to the latter, the collision with the Icarus, how can you be pursuing him for piracy, for an act of violence, that is, when the act of violence happens after the pursuit has begun? Isn't there a problem with the timing? So you can't quite rely on the collision with the Icarus to say we suspected him of piracy.
Your Excellency, we submit that the first incident that raised such suspicions was the Rosekill incident. And as for the collision with the Icarus, it fortified the proposition that Luz was in fact engaged in piratical activities. And therefore, Captain Haddock was justified in arresting him.
But that comes a point of arrest, not a point of pursuit. We haven't moved to arrest yet. For pursuit, as far as I can see, you cannot rely on the Icarus incident to say that is an act of violence for which you pursued because you suspected piracy. Which takes me back to the Rosekill incident. Where is the act of violence on behalf of Oscar de Luz in the Rosekill incident?
Your Excellency, as for the Rosekill incident, we contend that the manner in which the Daedalus approached the Rosekill put in danger the vessel and ultimately led to the tragic loss of 127 lives, as stated in paragraph 43 of the compromise. And this manner has been addressed, the manner in which he directed his vessel against the Rosehill has been addressed as in the various case law as being applied by Seychelles, Kenyan, Dutch and United States courts with regards to pirates as approaching a vessel in a manner akin to that used by pirates. We submit that in this case, Oscar de Luz did approach the Rosehill in such manner, and therefore the required evidentiary standard of reasonable grounds to suspect is satisfied.
I am not familiar with those cases, I'm afraid. Would you mind clarifying what is a manner of approach, which is what a pirate would do?
Your Excellency, as stated by the Seychelles Supreme Court in the Tupas case judgment, at paragraph 28, at 27, the manner in which the piratical skiffs in this case were navigated towards the victim vessel indicated that they were pirates, although they did not produce any gunshots or attempt to board the vessel. In the sentence of this case, they were convicted of piracy. Thus, it was proven beyond reasonable doubt that they were pirates. In our case, we submit
What's
that.
the most recent case regarding alleged piracy in EEZ? End of 2013? Are you aware? Are you aware of the most recent case? I mean, in this regard.
Is Your Excellency referring to the Enrique Alexian incident?
Excuse me?
I'm sorry, I cannot understand the question.
A
Can you
recent
repeat?
case law.
The most recent, not case law, but the most recent incident regarding alleged piracy in an exclusive economic zone of a particular state. End of 2015? Greenpeace?
Yes,
Are
certainly.
you aware of the... Do you know what happened to charges of piracy brought in that case?
Your Excellency, as far as I'm concerned, in the case of the Greenpeace activists, there were charges put against them of piracy because of their activities regarding.
Well, threatening the safety of the platform in particular, which actually sounds very much similar to the argument of endangering a vessel, like approaching in a particular way. So could you please compare this incident and the case law you referred to?
Your Excellency, I fear I'm not entirely briefed on this case, and that is why I cannot make appropriate comparison. In any way, we submit that combined with Luz's reckless behavior prior to his arrest, and given the fact that the Daedalus was stolen, as stated in paragraph 42 of the compromise, and restated in paragraph 12 of the clarifications to the compromise, it was reasonable to suspect that he was a pirate. Hence, Captain Haddock had the right to pursue and arrest Oscar de Luz. Moving to our second point of contention, Your Excellencies, Amalek had the right to pursue and arrest Mr. Luz due to the right of hot pursuit, as articulated in Article 23 of the High Seas Convention. The right of hot pursuit includes the right to pursue the Daedalus and arrest Luz in order to prevent infringement of Mali's immigration laws within the contiguous zone, as there were good reasons to believe that the ship pursued was engaged in human trafficking.
Right. You say there were good reasons to believe. What were these good reasons to believe?
Your Excellency, we submit that, first of all, the ACPS alert, as stated in paragraph 12 of the clarifications, spoke of the suspicions of the Daedalus being engaged in human trafficking. Furthermore, the fact of the suspicious behavior of Oscar de Luz, the fact that he tried to evade justice, the fact that immediately after causing the Rosehill incident, he persisted on navigating towards Amalia, even though knowing that he caused the incident with an Amalian ship, he still navigated towards Amalia at the risk of being caught. And this...
Was he only committed an act that actually concerned an Amalian ship? Wasn't it also the island of the second state? Basically, he didn't have many options.
Certainly, Your Excellency, the Excelsior Island was also there were also damages to the Accessory Island, and there are also 5 deaths of Italian nationals. However, we submit that as there were suspicions of the engagement of the Daedalus in human trafficking, the fact that he navigated towards Amalia after causing an
Was it a
incident.
mere suspicion or a reasonable ground to believe? Is there any difference in those two?
Your Excellency, we would note that believing is stronger than suspecting. But
You just mentioned that they had suspicions.
we submit that the evidentiary standard here consists of several facts that put together satisfy the required evidentiary standard. And furthermore, as for the good reasons to believe, they refer to the standard of good reasons to believe lies somewhere between mere suspicion and actual knowledge of an infringement, which is the current case.
Did Amalia have justification to pursue Mr. Delutz after he turned the ship towards Britannia?
Certainly, Your Excellency, as first of all, as the other requirements of hot pursuit were also met.
What are the elements of the hot pursuit, and should they be cumulative or separable?
The elements of the hot pursuit should be met cumulatively, as stated in Article 23 of the High Seas Convention, and as has been reaffirmed by the decision of the International Tribunal on the Law of the Sea in the MV Sega case number 2 at paragraph 146. We submit that all the requirements were cumulatively met. As already elaborated, there were good reasons to believe that the Daedalus was engaged in human trafficking. Also, we submit that as the pursuit commenced within the contiguous zone, this requirement has also been met. Thirdly, the pursuit remained uninterrupted throughout its entire duration. In the fourth place, the hot pursuit was undertaken by the Icarus, an Malian Navy fast response cutter, which meets the requirement for a warship to commence such hot pursuit. As for the next requirement, the pursuit ended within Britannia's uncontested EEZ, as stated in paragraph 46 of the compromise, which means no state's territorial sea was trespassed. As finally, prior to commencing the pursuit, Captain Haddock ordered the Daedalus to stop via radio, thus fulfilling the required auditory signals requirement. Now, respondent
Does
may...
it actually automatically satisfy? So does it satisfy the requirement, the radio signal?
Your Excellency, we do submit that a respondent may argue that Haddock's order to stop via radio were not enough to bring to his attention that he was being pursued, and thus the requirement was not met. This is not the case, however, as in the Mills case before the Croydon Crown Court in Canada, it has been stated that radio signals are sufficient in order to satisfy the required auditory signals. And furthermore, the fact that the Icarus issued an order over several of the most frequently used radio frequencies in the Strait of Malacca.
Let's not go there, because either radio signals are good enough or they're not. Doesn't matter how many frequencies you use. But with regards to a Canadian case, you are relying heavily on the Geneva Convention. Can this Canadian case overrule the application of the Geneva Convention that you are relying on?
Your Excellency, certainly it cannot overrule this provision. However, we submit that the provision of Article 23 of the High Seas Convention did not explicitly provide for the appropriate signals that need to be given in order to satisfy this requirement, and therefore radio signals may be regarded as satisfying this requirement.
As far as I'm aware, both UNCLOS and Geneva Convention do not mention anything about wireless being allowed. You know, the UNCLOS actually says that wireless is not allowed. So how can you get around the fact that the actual convention and the treaties drawn up go against you on this point?
Your Excellency, we do submit that this is the case. However, the United Convention on the Law of the Sea has not been ratified by Amalia, first of all. And secondly, as for the ILC stance in the Travel Preparatory to the High Seas Convention, in which it stated that radio signals must be regarded as not meeting the required standard as they're wireless. However, their concern was that those orders being wireless could be given at any distance. In our case, the Daedalus was within visual range, as stated in paragraph 45 of the compromise. Therefore, this contention must not stand. And as all of the necessary requirements for hot pursuit were cumulatively met.
I've got a general question on this. you are saying that UNCLOS doesn't apply. Then how can you be claiming EEZ? Because EEZ doesn't apply in the Geneva Convention on High Seas.
Your Excellency, there are certain provisions of the United Nations Convention on the Law of the Sea that were converted into customary international law. However, this does not apply to all of the provisions of the United Nations Convention on the Law of the Sea.
Only the good ones that you like.
Well, I would like to seek your view on the lawfulness of the arrest of Mr. Duluth. You have been very much relying on suspicion of piracy for the lawfulness of the arrest of Mr. Duluth, but he was not convicted for piracy. How would this impact on the lawfulness of the arrest?
Madam President, this would not affect our claim, as the sentence was given after the pursuit and arrest, and the requirement for the legitimate pursuit and arrest with respect to piracy is that at the time of the pursuit and arrest there existed reasonable grounds to suspect, and regardless of whether he was convicted or not of piracy, this does not affect the right to pursue him on such suspicions.
But what kind of new information appeared there after the moment of arrest by the time of the conviction that actually felt your state established that it's not piracy but some common crime?
Your Excellency, there are no facts in the compromise that elaborate on the matter, and this is a matter of our national courts, and we're not able to provide any more information
Can
on
you
that.
for us any example of state practice whereby a person arrested for one particular crime and, well, preferably pursued for a particular crime and arrested on the suspicion of committing and then would be convicted for a different crime, and how would it be treated internationally?
Your Excellency, there is no rule in international law that precludes the court to sentence a person on different grounds than those which were used in order to arrest him. Therefore, the fact that he was not sentenced on the grounds of piracy does not affect our claim.
Mr. Minchett, my apologies. You're short on time. Would you mind summarizing the remaining submission, please?
Thank you very much, Your Excellency. As for our fourth submission, we submit that, first of all, the respondent claimed in their written memorial that Amalia does not have the right to exercise jurisdiction over Luz because of the provision of Article 11, Paragraph 1 of the High Seas Convention. This article restricts the exercise of penal jurisdiction in cases of maritime incidents to the flag state or the state of nationality of the suspect. We will show that this article does not exclude Amalia's jurisdictional claim, and we have two major arguments in this regard. First of all, the Rosehill tragedy does not fall within the scope of Article 11 of the High Seas Convention because Luz was not legitimately in the service of the Daedalus as required by Article 11, Paragraph 1 of the High Seas Convention. Secondly, the rule of Article 11, Paragraph 1 of the High Seas Convention does not preclude the application of the passive personality principle on which we base our jurisdictional claim. Turning away from the application of Article 11 of the High Seas Convention, we submit that even if this court finds that Oscar de Luz was arrested illegally, Amalian courts still had the right to exercise jurisdiction pursuant to the Male Captus Benedetentus rule. And in conclusion, Amalia is under no obligation to return Luz to Britannia, as there is no extradition treaty in force between both states, as for the facts of the compromise, and states are considered to have sovereignty in affairs pertaining to exercising jurisdiction and deciding whether or not to extradite criminals to their countries of origin.
I have one question, and with Madam President's permission, feel free to answer if your time expires. You are claiming jurisdiction on the passive personality, but how can you have jurisdiction on the passive personality for the number of counts of murder that you tried him for, given that not all of those people were your nationals?
Your Excellency, we do submit that only 89 of the 127 persons that died on board the Rosehill were of Amalian nationality. And with regards to these, we can exercise the passive personality principle. As for the other 38 persons that were not Amalians, we rely on the fact that...
Just finalize your argument.
Thank you, Madam
Please,
President.
Mr. Minchett.
We rely on the fact that as they were on board the Rosehill, an Amalian ship under the exclusive flag state jurisdiction of Amalia, Amalia may exercise protection over them and in this regard exercise jurisdiction with regards to the deaths that were caused by the Roscoe incident by
Thank you
asbestos.
so much, Mr. Minchuk.
Thank you very much.
You can rest. Yes. Literally. Yes. So now the respondent, and we have Mr. Kosek. So, Mr. Kosek, it's your time now. You can commence.
Madam President, distinguished members of the bench, my name is Trajan Kosev, and it is a great honor for me to appear today before the International Court of Justice, pleading on behalf of the Republic of Britannia. I will speak for the following 22 minutes, addressing Britannia's first two submissions. The first one referring to the Excelsior Island project and Britannia's actions with respect to it, and the second one referring to the unlawful salvage of the carcass and the artifacts recovered from it. I will then yield the floor to my co-agent, Ms. Victoria Doceva, who will speak for the next 21 minutes, addressing Britannia's last two submissions. The third one referring to the illegal pursuit and arrest of Mr. Deus, and lastly, Amalia's lack of jurisdiction to trials. And we respectfully request the court for 2 minutes for Sir rebuttal. Madam President, may I please the court. With relation to the first claim, applicants submitted two main arguments. First, that Britannia did not obtain consent and authorize the dredging activities without a prior approval, and therefore has breached the Malachi Gap Treaty. And second, that Britannia has breached customary international law by not conducting a complete environmental impact assessment. Your Excellencies, on behalf of the respondent, we submit the contrary, that Britannia has fulfilled all of its treaty obligations under the Malachi Gap Treaty.
And they were?
Your Excellency, I will immediately move to the obligations under the Malachi Gap Treaty. In what we have heard from the applicant says that there should be a prior approval by the state of Amalia for the authorization of the process. Your Excellency, there is not a single provision in the Malachi Gap Treaty that provides for such obligation that Britannia had, namely the obligation to acquire consent. And Your Excellencies, the tribunal in the Lake Winnow arbitration has stated in page 101, and I quote, "Conduct of a prior agreement between the interested state cannot be established as a custom, even less as a general principle of law. Therefore, Britannia is not obliged to conduct an agreement in order to authorize the Excelsior Island project, Your Excellencies."
But the treaty that you're referring to requires from Britannia cooperation and negotiations in good faith. Did Britannia perform like this?
Certainly, Your Excellency. Article 12D refers to the duty to cooperate, and several points must be made with respect to your question. First, the duty to cooperate should be distinguished from the consent obligation, Your Excellency. And as to the negotiations, yes, Britannia has proposed bilateral negotiations, which we can see by paragraph 26 of the compromise, Your Excellencies, and they continued for a whole year. However, since Britannia is not obliged to conduct an agreement or to obtain the consent, we submit that the duty to cooperate has been successfully fulfilled by namely proposing those bilateral negotiations, Your Excellencies.
But going back to the consent, didn't the Malachi Gap Treaty divide the rights belonging to Amalia and Britannia with regard to the activities performed at the Malachi Gap?
Yes, Your Excellency. And
so basically, the activity envisaged by the construction of the island didn't it actually touch upon the rights of Amalia directly, provided for by paragraph A of Article 12 of the treaty?
Your Excellency, paragraph A it states that Amalia has the right to export and exploit the waters superjacent to the seabed.
Excuse me, explore and exploit, just that?
And protect the natural resources, Your Excellency. However, paragraph 12b states that Britannia has the right to, again, protect the natural resources and exploit and explore the subsoil and the seabed.
I think the point that my sister judge is making and the applicants were making is, under Article 12C, this is an oil for fish treaty. You got your oil, but they didn't get their fish, and as such, you're in breach.
Your Excellency, we submit that Article 12C has not been breached by Britannia, and the And the rights of the applicant has not been unduly inhibited, Your Excellency, which is precisely the provision of Article 12C.
Well, how do you interpret this word?
Unduly inhibit. Your Excellency, Britannia should not take any actions that would unduly inhibit the rights of the other state party, Your Excellencies. And your questions, Your Excellencies, leads me to the second argument of the applicant, namely the Customer International Law and the environmental impact assessment, Your Excellencies. And the environmental impact assessment was complete, and Britannia fulfilled its obligation.
But it was not full. It did not actually touch upon dredging at all.
Indeed, Your Excellency. However, as this court has stated in paragraph 205 in its decision in the Pope News case, it is upon each state to decide the particular object and scope of the environmental impact assessment, Your Excellency. And therefore, since international law does not regulate the particular content of the EIA,
Is it only the Falklands case that's applicable to the situation?
certainly not, Your Excellency.
Is it sufficient to say that there is customary international law by relying on one case of this court?
Excuse me, Your Excellency.
Is it sufficient to rely upon one case of the ICJ to establish a customary rule in a particular area?
No, Your Excellency. There should be a sufficient state practice and opinion interest, certainly. However, there is customary international law with relation to the EIA, but this does not include the particular obligation concerning the content of the environmental impact assessment, Your Excellency. Right?
And we know that from the Falklands case.
From the Pope News case, Your Excellency, and also, if I may now recall, Principle 17 of the Rio Declaration, which provides that environmental impact assessment as a national instrument shall be undertaken for proposed activities, and moreover, again I quote, that are subject to a decision of a competent national authority, Your Excellencies. And we can see by clarification 6 that all the governmental authorities were consulted, and moreover, that the returning department.
So basically, by saying that all governmental authorities were consulted, you are basically saying that all of the governmental authorities of your country were competent to consider this issue. So the competence to consider this assessment is like the competence of each and every state body of Lithuania?
Your Excellency, we submit that the particular object and the content is regulated by the domestic legislation of Lithuania. And therefore, we submit that since all the governmental authorities authorize the project, the environmental impact assessment should be considered.
What's the relevant authority for preparing the assessment in Lithuania?
It is that the assessment was conducted by EIGP and was reviewed by the Lithuanian Department of Managing Resources, which has authorized the particular environmental impact assessment.
And Britannia totally disregarded the report that was provided by the American Foreign Minister that was prepared by the International League of Sustainable Aquaculture, where it is stated, this is in paragraph 25 of the compromise, that there is potentially there could be potentially catastrophic impact on the native species and the ecosystem.
Madam President, your question leads me mainly to the issue concerning the user report, and Britannia is not obliged to take into account the user report. An applicant quoted a paragraph from the Bosnian genocide case, and in response to that, I would like to refer the court to the Nicaragua case, where in paragraph 64 of the merits, the court stated that, I quote, "will treat with caution evidentiary materials specially prepared for the case, and also materials emanating from a single source, Your Excellencies." And moreover, again,
Have you read the remaining paragraphs in that judgment? Because it goes on to say that actually we do take it into account and we give it the appropriate weight.
Indeed.
So you're quoting the bit that again helps you, but you're not quoting paragraph 66, which kind of says we can't take it into account.
Yes, Your Excellency. However, the user report was the only source, and a single source, and uses precisely the language that there is a possibility for the occurrence of the landslide, Your Excellencies. And since the customary obligation, namely the due diligence obligation to which applicant refers, is, let me emphasize, one of conduct In adjudicating this decision, this court should not take into account the mere occurrence of the 2009 landslide, but instead should decide whether Britannia has adopted the necessary measures for preventing the possible occurrence, Your Excellency.
So Britannia considered it unreliable regardless of the fact that it was an independent report provided by
Yep.
by the Equatorial.
Yes, Your Excellency. It was a report provided from a non-governmental
Yes,
organization. Moreover, it was issued by the state of Amalia, and the report uses words like possibly and likely. And
Well, isn't the word likely directly relevant to our issue here?
no, Your Excellency, since there is not certainty that the landslide would occur. And
What are the elements of the significance of boundary time definition?
Your Excellency, there should be a risk, and there should be,
Should be?
there must be risk, and there must be significant evidence with relation to that particular risk, Your Excellencies. And in that particular case, the ILSA report was not sufficient evidence to provide that the landslide would occur with certainty.
But was it the exact reason why the report was declined by the Lithuanian authorities? The reason, the contents of the report. What was the reason, according to the contrary, the report was declined?
Your Excellency, the reason, according to the ambassador, was that Britannia did, that since the island is built entirely outside the Malachi Gap,
Excuse me?
since the Excelsior Island project is situated entirely outside the Malachi Gap Treaty in the exclusive economic zone of Britannia, it is upon the state of Britannia to decide whether it can authorize or it cannot authorize dredging activities.
Joseph, I think there is a different question that has to be answered before we even get there. Fine, you can disregard it, but you need to consider it before you disregard it. The problem is, the state agency which has to do that was never given this report because it was dismissed by the ambassador. An ambassador doesn't have the capacity to make that determination. The agency does. So it's in fact your ambassador who is in breach for not forwarding it, not the agency for not considering it.
Your Excellency, yes. However, Britannia did have the knowledge to the report, although it was dismissed by the ambassador, Your Excellency. But
Let me put it this way. You say that the report didn't have to be considered because it is exclusively in EEZ and so on and so forth. Is your ambassador an expert in this field?
Your Excellency, certainly not.
In which case, how could he make the determination?
Excuse me, Your Excellency.
How could he make a determination that this report is irrelevant and it's from a single source and under international law it doesn't have to be considered?
Your Excellency, the ambassador is a state representative and has the right to not inform the competent authorities considering the report. However, the report was announced to the public.
What if it was an intern in the embassy and the intern's son's second cousin is given the report to photocopy to be passed down the chain and he just bins it because he can't be bothered?
Well, in that case, Your Excellency, Britannia cannot be held responsible for those actions.
Well, you would say this person did wrong.
Certainly, Your Excellency.
In which case, what's the difference between that second cousin's intern and the ambassador, who again doesn't have competence or the capacity to make that determination, equally that the intern doesn't?
Your Excellency, the ambassador certainly should have passed the report to the competent authorities. However, Britannia is not in any case obliged to take into account the particular provisions of the ILSA report. And Your Excellency, now moving.
So shouldn't we find a violation here that an agent of your state actually failed to communicate the report, which did not allow you to make an assessment?
Your Excellency, applicant did not involve that particular situation, and this would not form the very subject matter of the present dispute. And if you allow me now to move to the issue concerning the compensation, Your Excellency.
You're running short of time, so go.
Since there is not an international wrongful act, Your Excellency, Britannia should not be responsible for the landslide. and does not own any compensation to the state of Amalya, Your Excellencies. And moreover, the applicant stated that by all accounts, the dredging activities led to the negative impact over Dorian Ras fish, Your Excellency. However, the EIGP is a private operator, and as the court stated in paragraph 454 in the Diao case, there should be sufficient direct causal nexus between the link and the damages, Your Excellency, which is not present in that case.
So basically, are you saying that under no circumstances can this court find a violation on the part of the state for actions of private parties?
It certainly can, Your Excellency, under Article 8
Under what conditions?
of the Acts of State Responsibility.
Only Article 8.
No, Your Excellency, if this court accepts that Britannia is responsible for an international wrongful act, then we submit as our alternative that Britannia is not bound to pay a complete, full compensation, Your Excellency.
Under what conditions, that was the question, could the state be held responsible for the conduct of private persons?
Your Excellency,
Mhm.
under the House Articles on State Responsibility, there is also a doctrine of strict liability. However, we submit that this doctrine is nowadays not part of customary international law and does not apply in the present dispute. And therefore, Britannia is not obliged to pay any compensation to the state of Amalya, Your Excellency. And
I think we're getting off track with attribution, causation, and strict liability. Can we just move on?
yes, Your Excellency. Moving to the second issue concerning the ownership over the artifacts recovered from the carcass and the illegal salvage operation. Applicant stated that the artifacts were actually booty for Your Excellency, and also there is a customary international law providing that the artifacts should stay in the Amalya, Your Excellency. However, Your Excellency, applicant exclusively relies on figur gratius in order to prove the law of the 16th century. But there is not a single provision in the compromise that provides that there was actually war between the two states, the state of Amalya and the state of Britannia, Your Excellency, in 1510. And if I may respond again to quotation of figur gratius, which stated, declarations of war, in fact, as we shall shortly be saying, were wont to be made publicly with a statement of the cause in order that the whole human race might judge the cause, Your Excellency. So there should be a declared war in order for applicant to consider the artifacts booty for Your Excellency. And
Is it the only way to establish that, the war?
certainly not, Your Excellency. This was pointed out by the applicant. However, we submit, on the contrary, that the artifacts are cultural property of Britannia, and therefore Britannia is the rightful owner of the artifacts, Your Excellency. And the definition of cultural property provides that these are objects which are...
Where do you find this definition?
The definition is included in the 1970 Convention, the UNESCO Convention on illicit export and import of cultural property, Your Excellency.
Are you part of the convention?
No, Your Excellency. However, we submit that the convention is now part of customary international law, and this.
Why?
There is sufficient safe practice and opinion, Your Excellency. First, the convention is ratified by more than 100 states, and there are 3 General Assembly resolutions referring to that convention, Your Excellency. Also, the Security Council resolution, namely the Security Council Resolution 661 and 1483, awarded restitution to cultural property of Iraq, although Iraq was not a state part of that convention. Your Excellency, Article 4 of that convention provides that the cultural property is of a great importance to a state. And in the present case, the Helen coronet and other artifacts are certainly of great importance, since they are even of mythical importance.
Sorry, you say the coronet and other artifacts. You don't even know what these other artifacts are. How could you possibly know their importance?
Your Excellency, the artifacts, we refer to the artifacts that were recovered by the siege of Hellas before 500 years, and whose we claim ownership only over those artifacts and the head and coronet.
That's fine. What we did, the coronet, fine. It was of cultural importance to you. What about the others?
Your Excellencies, they are also cultural property of Britannia, and Britannia acquires ownership of.
How can you say anything about their significance if you don't know what those artifacts are?
Your
In
Excellency,
addition, I'm sorry, you have to be mindful that the ship of Mr. Verdigris was coming from another voyage, so to say. So we don't know what was on the ship before this attack against the
Certainly, Your Excellency.
Mhm.
the ship was returning from the paragraph 33 of the compromise for a successful trading commission, Your Excellency, and moreover was financed by private backers, and therefore the ship cannot fall under the definition of a warship, Your Excellency. And if Onelec claims ownership, it may claim ownership only over the shipwreck of the cargoes, Your Excellencies, not to the artifacts recovered 500 years ago during the siege of Helios, Your Excellencies. And regarding applicant's argument concerning the customary international law, applicant did not provide any state practice or opinion juris concerning the customary international law.
Let's say, going back a bit, let's say we argue with your argument on World War II, that there was no state of war. However, as a privateer, you could still sack, and that would belong to the state from whom you had a letter of marque.
Indeed, Your Excellency. However, the letter of marque was provided for a naval operation, Your Excellency, and the siege of Helios in 1510 cannot qualify as act during the war, Your Excellency, since there was no explicit declaration.
There doesn't have to be a state of war for a privateer to take objects.
Yes, Your Excellency. However, the mere taking of the objects does not provide Tamila with ownership over those artifacts. And
Why not?
because, Your Excellency, there should be a legislative process concerning the letters of marque. This process is condemnation, and
In the 16th century,
yes, Your Excellency, and
please give me your law, because I am ignorant of this one.
Your Excellency, we can provide the court with a case from the Pennsylvania Supreme Court, where the court stated that
Of the 16th century?
17, Your Excellency. Madam President, I think that my time is up.
I'm sorry, Pennsylvania Supreme Court in the 17th century
Yes, Your Excellency.
didn't exist.
According to our information, and I apologize for the court.
Your time is over. Thank you so much,
Thank you, Madam President.
Mr. Kosip. Now, Ms. Docheva, she is invited to approach the bench.
Madam President, honorable members of the bench, my name is Victoria Docheva and I appear as an agent for respondent, Republic of Britannia in this case. I will be speaking for the following 21 minutes, addressing Britannia's last two submissions. The third one with respect to the unlawful hot pursuit and subsequent arrest of Mr. Oscar Dulus, and the last submission on the respondent's part that Amalea lacked jurisdiction to trial us in connection with the Rose Hill incident and its duty to return him back to Britannia. Starting with my first point, applicant claimed the argument with the piracy as a good reason to believe that there was an actual violation of the laws, and also the human trafficking argument for a violation establishing the good reason requirement. The hot pursuit was illegal for four main reasons.
Counsel, before you proceed on the merits of the argument, are you appearing before this court with clean hands in respect of this matter? Could you please address this question?
Yes, Your Excellencies. The doctrine of the clean hands provides for, as well established by this court, for a bar of a state to claim rights if it breached those rights to other states. However, this is not the case with respondent in the present fact pattern, because the unlawful hot pursuit with respect to Mr. Oscar Dulus was conducted in breach of customary international law and also treaty law.
But wasn't your failure to pursue Mr. Ross couldn't be considered a violation? I mean, didn't you have an obligation to pursue this person?
we didn't get the chance as a state to do so because the facts of the case show the very short period of time when the whole thing happened with the hot pursuit, the Rose Hill incident, the collision between the cars and the Daedalus. And as
How
state,
much time?
it was less than a 24-hour, and for this reason,
But how much time would you need to engage in the pursuing stolen yacht, for example?
well, in the given fact pattern, it is not clear whether Britannia was informed about the Rose Hill incident to start pursuing, and moreover, the pursuit.
If you have to be informed of this incident because it concerned your territory, I believe.
The actual knowledge is essential in this part because the Rose Hill incident happened in the exclusive economic zone, not so close to the, with respect to the coast of Britannia. So the actual knowledge of the coastal state Britannia with respect to the Rose Hill incident and the pursuit of Mr. Duluth needed some time in the present case.
Who would need to inform you of the incident which happened in the Excelsior Island?
Well, this information is not clear from the case whether at what time exactly this information was transferred to Britannia's authorities, and therefore we cannot make any further submissions with respect to that question. If you allow me to proceed with my argument, I would like to point out that the 4 requirements of the hot pursuit were not met, and as a respondent agrees with applicant that they should be given cumulatively, as stated both in the Geneva Convention on High Sea and the Saiga D case. So even one of those requirements is found by this court not met by applicant, it should rule that the hot pursuit was conducted unlawfully.
Well, what about piracy?
The piracy exception does not has not been met the requirements of piracy as established by Article 15 of the Geneva Convention on High Sea. There should be an act of violence for private hands committed on high seas against another ship. The requirements are not met in the present case for several reasons. First, there was no another ship in this present case because there was no collision or act of violence towards another ship. The only conduct of Mr. Oscar Duluth with respect to the Daedalus was to navigate it recklessly, but it did not attack Rose Hill as attack supposed pre-organization, and it is also noted by applicant that there was no use of force, weapons, or any kind of typically used items for attacking another ship. So the 2 ships requirement is not met in the present case. Moreover, the private ends requirement is also not present. This is because at the very distress of Rose Hill, where it should have been considered as most vulnerable for attack, that was just steered away. He did not.
I would move away from that one because the private end is supposed to be opposite of public end. So let's not go there because I don't think you will be doing very well on that point. But the argument of the applicants was with regards to, for example, relying on a case from the Seychelles, that just directing the ship at another ship is enough to constitute violence.
With respect to that, several cases of China in its territorial sea points out that mere navigating of reckless is not enough to constitute a piracy because all of the requirements should be met, and just a reckless navigation of
not just reckless navigation, but navigation directly towards another ship.
Well, it was perceived by the captain of the Rose Hill, the cruiser, that it was toward the ship. However, when we consider the 2 vessels, it is one of cruiser, huge cruiser of 556 passengers on board, and a small Daedalus, which is a yacht with less than 10 people on board, which can be considered as not to be perceived by the captain as an actual act of violation.
Where are you getting the sizes of these ships from? I don't remember the company talking about the size.
And
Well,
the the number of people on board of the
It is in paragraph 42, I believe.
42 says what the size of the Daedalus is.
Well, it is says that it's a yacht, and it is also says that less than, it was not clear the exact number of the passengers supported, but
It could be the size of the Titanic with 10 people crewing, manning the crew. We don't know how big it is.
well, we know, Your Excellencies, because actually there was a request from Amalea to navigate, for Rosehill to navigate closer to Excelsior Island, and actually Britannia and Amalea both were aware that Rosehill was actually a huge cruiser with 556 people on board. With this, I would like to establish that no piratical act has been committed by Mr. Oscar de Luz, and therefore Amalea had no reason to start a hot pursuit for the exception of piracy. With respect to the good reason requirement with human trafficking allegation, I would make just the point that paragraph 147 from Saiga case pointed out by applicant, I would briefly quote on it just to show you that there is an establishment for high threshold of the good reason requirement, and mere suspicion cannot suffice this high threshold.
Do you remember the facts of MV Saiga, what the mere suspicion was?
The mere suspicion, Your Excellencies, was that the MV Saiga case provided with oil the fishing vessels in the exclusive economic zone of Guinea, and therefore it violated its economical rights in the zone. For this reason, however, the International Tribunal for Law of the Sea found that this was just a mere suspicion and could have no more than a suspicion that a tanker had violated the laws of Guinea, and found that it is not enough to start lawfully hot pursuit. With respect to the human trafficking, there was just a mention in the alert that the human trafficking, the Daedalus was suspected of human trafficking. No conviction afterwards, nothing to show that there was real violation of the immigration laws of Amalea. Furthermore, Your Excellencies,
I mean, is the subsequent conviction is a necessary condition for the reasonable ground to believe?
it is not, Your Excellencies, but it shows that the state has recognized that no such violation of immigration laws has been committed subsequently. We can point to this, however, the moment where it should be assessed is when the Navy of Amalea received the alert describing the Rosehill incident, and the alert was issued on first place for the Rosehill incident, and it would be and the mere mentioning of the human trafficking suspicion cannot suffice the high threshold, the good reason requirement. To provide you with substantial interpretation of the good reason requirement, I will point out the International Law Commission report from 1956, where it is stated that evidence that an actual violation has occurred is needed in order to suffice the good reason requirement.
But where would this evidence be found in your case? Would it be found in Amelia or in Britannia?
Well, this, as the coastal state in the present case, Amalea started the hot pursuit. It should have, it was on Amalea part to have the evidence showing that actual violation of its laws and regulation has been committed, and the human trafficking notification by the Amalea Coastal Protection Services in paragraph 44 of the compromise cannot suffice the good reason requirement, as stated both by the International Law Commission and in the case law, namely the Saiga case. Moving to the other requirement, applicant relies exclusively on the Geneva Convention on High Seas, which provides for only 12 miles of contingent zone, and therefore it should be noted that the hot pursuit started from 23 nautical miles from the baseline of Amalea, and therefore this requirement is not met in the present case. They did not point out to UNCLOS, and as it stated in the compromise, Amalea is not party to the UNCLOS.
Well, maybe that's why.
Well, they, in the clarification, Your Excellencies, it is true they claim the contingent zone, but however, as it is the assertion of applicant, they exclusively rely on Convention on the High Seas. This should be taken into account by this court.
I think the applicants did make the point of they are relying on EEZ in response to my question, because it character. And I would imagine they would have the same argument for the contiguous zone being 24 nautical miles.
I'm familiar with the exclusive economic zone status of customer international, as pointed out by this court in two cases, Gulf of Maine and Libya versus Malta. But for the contingent zone, this should be established specifically, as those two zones are different kind of zones, and applicant has the burden to prove that it actually has a customer international law character. With respect to the radio wireless signal, here the requirement is evidently not.
You say they need to claim it, and clarification 3 says they have claimed 24 nautical miles.
To establish the rule that the contingent zone has customary international law with respect to apply it as the right course. Your Excellencies, with respect to the signal given to Mr. Oscar de Luz, the radio signal was falls under the wireless signals, and it is applicant is barred to assert it as a lawful signal provided to the pursued vessel, as stated in the RV Mills case and others, can be wireless signal because it is excluded also in the International Law Commission, by the International Law Commission, in its yearbook, that signals transmitted by wireless cannot suffice the audio and visual requirement.
What year is that?
It is 1956, Your Excellencies, page 285, volume 2.
Are you aware of the subsequent practice in this regard? Case law. Does there exist any case law in this regard?
Well, the case law that provides for radio signal is only based on national courts of the United States, namely which are not widely accepted in
I'm
this
pretty
case.
sure ITLOS has commented on this. Are you familiar with what
Yes.
ITLOS has said
I am.
about use of wireless?
Yes, Your Excellencies. In the MV Saiga case, again, in paragraph 156, it is stated that the radio signal cannot suffice for wireless. Furthermore, there has been pointed out there.
Are you sure SIGA says that?
Yes, Your Excellencies. I will point me.
Because as far as I recall, MB SIGA, the judge says something along the lines of, this is what the assertion is, but he doesn't say that that is correct. So the natural interpretation from MB SIGA is that wireless can be used.
Well, the interpretation of the Saiga facts on the matter should be inferred by the fact that the captain of the Saiga ship objection has led that he ever perceived the signal has been enough for the tribunal to find that the audio and visual requirement has not been met in the
Can
present
you
case.
just let me know what paragraph of MB SIGA you are relying on?
It is 156, Your Excellencies, which points out also to the I'm Alone case, where it is stated that an endangerment of other vessels, like sinking the boat, is excessive use of force with respect to the hot pursuit. And as I see my time is fast elapsing, I would like to address the last issue on the matter with respect to the passive personality principle on which applicant exercised jurisdiction over Mr. Oscar de Luz. First, they rely on the dissenting opinion of the Lattes case only in their written memorials, and where the Lattes case established the passive personality principle, it is highly criticized case and overruled by 3 international instruments, namely the conventions on high seas, the UNCLOS convention, and the convention with regard to certain criminal activities at sea. With respect to that, the passive personality principle is very controversial and should not apply to the incidents of navigations and collisions, because, Your Excellencies, there is established not just the flag state jurisdiction, but exclusive flag state jurisdiction, Your Excellencies. And this prevents applicant from exercising passive personality jurisdiction. Furthermore, the passive personality principle is applied in the Eichmann case, on which applicant also relies. But it is stated that it applies only to certain kind of crimes with respect to crimes against humanity, war crimes, and genocide. So with this
Excuse me for interrupting you. Are there some exceptions from the flag state jurisdiction?
Yes, Your Excellencies, the hot pursuit is one of those exception, but as commented before, it is not executed properly to satisfying all of the requirements.
You made your points
Thank you.
previously.
So the passive personality principle is not applicable for collisions at seas, incidents of navigation, and Britannia enjoys exclusive flag state jurisdiction pursuant to Article 97 of the UNCLOS Convention and Article 11 of the Geneva Convention. With respect to the comment on the Male Captus
I'm sorry,
Benedict,
the applicant dismissed that argument by making one argument, which is the argument of the laws being not the captain nor in service of the ship.
we will address this in turn. First, the flag of the state and who is captain or not is in the exclusive domestic legislation and the discretion of the flag state jurisdiction. And as Britannia has not expressed any,
Where do you take this from?
it is Saiga case paragraph 65. And furthermore, Your Excellencies, as Britannia has never made any allegation with respect to withdraw the flag of the state, it should be noted that Daedalus enjoys the flag state jurisdiction. He was in full control. The facts of the case does not provide.
Is he captain or in service of the ship?
Well, it is a yacht, so we can infer only that from the facts which are scarce in this particular case on the matter, that he was in full control, Mr. Luz, and therefore we can infer he was properly provided with the documents requiring operation. Well, this was mentioned in the alert of the Malian Coastal Protection Services. However, it was never proven. So, with respect to the stealing, even if it was stolen, it was within the territorial waters of internal waters of Britannia. So, Amalia has no jurisdiction on that matter. With the Male Captus Benedictentus doctrine, I would like to address that this doctrine is highly criticized. It is overruled in many national cases, say versus everything, South Africa, ex parte Bennett, England, also in Yorlis, France, where ordering the release of a defendant who was abducted in violation of international law by French agents in Belgium. And with respect to that, I would like to point out this court that when the arrest was illegal, as the pursuit was illegal in the first place, no jurisdictional basis can be exercised with respect to a foreign national, as this will constitute a breach of international law. Pointing out to the...
Could you request the return of Mr. De Woods?
Yes, Your Excellency.
On what authority would you rely?
This is in the fact of the compromise, I think it's 56, where the Britannian authorities numerous times requested Amalia to return Mr. Oscar De Luz. And they rely on the Icon case that no return has been given, but there in the Icon case, Argentina waived its right to seek return of Mr. Oscar De Luz, while Britannia insists on Mr. Oscar De Luz returning.
On what grounds can you claim extradition or return of Oscar De Luz?
Well, this should be a mutual agreement between the parties or a customary international law, as we don't have, the fact of the case does not provide this court with...
What are you asking the court to do?
We ask this court to return Mr. Oscar De Luz to Britannia as a state of origin, as Amalia is barred to exercise lawful jurisdiction.
Under what basis?
Because the passive personality principle does not apply and the...
Fine. They have no jurisdiction to do anything with him. But there has to be a positive obligation to allow us to force a return. Where is this positive obligation coming from?
Well, may I answer the question, Your Excellency?
Fine, of course, you have to answer the judge.
Thank you. The audedere audedicare doctrine relies on when a state has no legal basis to prosecute a foreign national, it should return it on the requested state, to the requested state. We interpret this doctrine in favor of Republic of Britannia, and with this I would like to thank you for your kind attention, and if you don't have any further questions, we conclude my presentation.
Thank you, Ms. Rocha.
Thank you.
Time is over.
Madam President, Your Excellencies, I will address 2 points from the oral pleadings of our esteemed opponents. namely the content of the environmental impact assessment and the application of Article 11.1 of the High Seas Convention. With regards to the first claim, the respondent claimed that the environmental impact assessment was in accordance with international law standards, relying entirely on the argument for its compliance with municipal law. Indeed, in paragraph 205 of the pulp mills case, the court expressed the view that it is up to each state to determine the exact content. However, 2 points. In paragraph 205, the court went further, assessing that states must have due regard to the magnitude and the size of the project and its likely adverse impacts. And secondly, under Article 27 of the Vienna Convention on the Law of the Treaties, Britannia cannot invoke the provision of its internal law as justification for the non-compliance with the international obligations incumbent upon it. We see from the commentaries to the draft articles on responsibility of states that an environmental impact assessment is meaningfully prepared when it assesses the possible negative impact from the dredging, which in this case is the impact on the Dorian wrasse population. And on our second contention, with regards to the claim of the respondent and the application of Article 11 of the High Seas Convention, we submit that the respondent cannot rely on the application of this article, as the Daedalus was under the control of Luz, as evident from paragraph 42, but there is nothing in the compromise that states that he has been the master of the ship and has a master license.
I'm just going to take you back to your reliance on the Vienna Convention law treaties for national legislation. What if, as they have said, the law requires obligation of satisfaction only within the domestic legislation?
Can you paraphrase your question, Your Excellency?
What I'm saying is you can't rely on national legislation, but international law says in this aspect you have to have national legislation.
Your Excellency, we rely on the fact that the court indeed said you should provide for the content of the environmental impact assessment in the national law. However, this should be in accordance with the international standards for the appropriateness of this assessment of possible harm, as stated by the International Law Commission in their commentary on the draft articles on responsibility on transboundary harm. And namely, there it was required that states should conduct and present meaningful environmental impact assessments.
Thank you, Ms. Borislavova.
Thank you.
Your time is over. So now, please proceed with the recital. What are the issues that you would like to address?
Your Excellencies, respondent will address issue 1 and 2 of the report of the applicant, Your Excellencies. With relation to the first issue, applicant stated that paragraph 205 is not sufficient to provide that the particular object and scope of the environmental impact assessment should not be under the domestic legislation, Your Excellencies. However, Your Excellencies, we admittedly accept the fact that EIA is part of customary international law, but the particular object and the content of the environmental impact assessment, Your Excellencies, are upon each state to decide upon the particular object and scope. And except those paragraphs, we quoted Rio Declaration in Principle 17, which once again, reaffirms that it is upon each state to decide the particular content and object of the environmental impact assessment, Your Excellencies. And since Britannia was not obliged anyhow to conduct EIA concerning the Dorian wrasse fish, Your Excellencies, we submit that Britannia has complied with its obligation concerning that particular environment.
Even if this is going to cause catastrophic consequences for the region.
Your Excellencies, this concerns the ILSA report, which was the only single evidence. And we provided the court with cases, namely the Nicaragua case, and again in the Old Portland case, in paragraph 63, the court stated that such reports are considered as a secondary source, Your Excellencies, and therefore the ILSA report was not a sufficient report, evidence to provide foreseeability or predictability concerning the possible impact of the 2009 landslide, Your Excellencies.
Although the facts of the compromise show otherwise. So please proceed with your second point.
Your Excellency, just to the second point, since I see my time is up, there is no instrument which requires the...
Would you please like to shortly address this?
Yes, I want to hear the second point.
Yes.
Your Excellency, there is not a provision which, under international law, requires a specific obligation for concerning the master of the ship or how he should be legitimately identified, Your Excellency. Therefore, as my colleague stated, it is upon the domestic legislation to decide the particular issue, Your Excellencies. Madam President, Your Excellencies.
Before you sit, have you looked at Article 11A of the Geneva Convention on the High Seas?
Yes, Your Excellency.
And it doesn't say anything about what a captain is supposed to be.
Your Excellency, I'm not particularly familiar with the exact provisions of Article 11 at this particular time.
Thank you so much, Mr. Kosik.
Thank you, Your Excellencies.
So, we announce the final results of this competition. Of course, before that we're going to make some very short assessment about the way the team of the applicant and the team of the respondent presented their arguments, their cases, and thereafter I will announce the result that is unanimously taken by the members of this bench. So we shall go now with the judge sitting to my left.
My apologies, this is a bit weird where I have to lean in, but I will keep this brief. My name is Subrush Katyabadi. I have been involved in Jessup probably for too long, since 2006, as a competitor, as a coach, as a judge, in here, Russia, UK, Washington, Brazil. I'm a bit of an addict when it comes to Jessup. So, first and foremost, congratulations to both teams. Well done. I have been there, I know how difficult it is to go through the entire process and how much time and effort and dedication it requires. Winners and losers, be proud of that. Producing the memorials should give you a bit of comfort that you were fantastic. Sitting in the final should make you particularly happy, and I do hope that you will come back. Do it again, compete again, or come back and coach, come back and judge. And the same with the other people in the back. I recognize some familiar faces around who have been coming back, some from same universities, some doing it with different universities. So spread it as much as you can, and it is rewarding. You will forever find someone else who's done Jessup and who will remember and relive your memories of memorial submissions, the tears that you had to cry to make that deadline as 11:58 is ticking on. So, well done. The general comments I would make to both teams, and I do invite anyone who does want anything more specific to come up to me afterwards. First off, when you are researching your arguments, be prepared that some of your arguments might not be favoured by the judges, in which case you need to have backup arguments. At any given time, have backup arguments ready, alternatives. Secondly, when it comes to the arguments that you do make, don't necessarily run away from the questions. There are instances where I might not comment on it, but just moving on becomes very obvious to the judges. In terms of style, be careful with your hand movements, your facial gestures, anything which is too erratic or too repeated kind of sticks in the mind. So try to avoid it as much as possible and be very mindful of your pace. I know you're trying to finish everything and I know you have a limited time. My view has always been, and I know everyone doesn't agree with me, if I am asking too many questions and keeping you on one point, don't worry if you don't have to finish, if you can't finish. Try to maintain a pace which is comprehensible to the people that you're speaking to. Finally, well done both on rebuttal and surrebuttal. That, I actually rarely see a rebuttal which is good, so well done, that was quite a good rebuttal. And surrebuttal, you did well to survive, because those were good rebuttals. So that part of the actual competition between the two, I would say you guys did fantastically well. I will leave that as my comments, and I will pass to my sister judge.
My name is Maria Saila, and my experience in dress exceeds the ridiculous number of years I served by 4 years. So I started in 2002 as a competitor, and ever since I was involved as a judge or in the Russian National Administration for the past 6 years. Thank you very much for the impressive presentations of the two teams and overall the impressive quality of the rounds, the organizers, and for inviting us here. Well done to the two of you. And I think you're a silly sport that you should be proud of what you've done by this time. Dress-up is strange in a way because it makes you suffer like for many, many months. But then you will remember it as one of the happiest times of your life. We don't know why is that, but anyway, it is. So I encourage you to take part more and more as your students because you will have like forever to judge afterwards. But taking part is just the time is limited. So live it from that as much as you can. Well, in terms of the comments, those would also be general comments applicable to the post teams, and I know that, it's something that many teams actually maybe pay less attention to, in my view, than they should, is that in order to win the JASA, you not only need to know the law, you will also need to communicate it successfully to 3 judges who come from unpredictably like various backgrounds, various countries, everything. Basically, it's also very much a psychological exercise. For this reason, but it actually, I think it adds to your task. And I think that, basically do not be afraid of spending time on shaping your presentation. Because, I would never think myself of that, but for example, I keep recalling this presentation which I once faced in DC, which actually was like a website. I'm judging and there's this participant, and he I just see it as a website. So basically then I go question, and then as if I click, and then he unfolds the argument there. And I still don't know how they did it, but apparently it's a strategy. And I know that worldwide there are universities who have developed some secret knowledge for a particular university, how to win the JASA. But it's not only about the church, although it's the most important part of everything, but it's also about that, how you actually deal with judges. So that would be one advice for everyone to concentrate
I'm not a participant in the Jessup competition. This is my first experience. Although I have to say that I have enjoyed it very much, and I had a brother and a sister judges, extremely very much experienced as well. I have to say that obviously Jessup is a very special family, and if you are now contestants in this competition, in years to come you will be trainers, you will be judges. So quite late in my life, maybe I will join the family of the Jessup, hoping that I would be able to make my contribution as well. I have to say that I was very much impressed. I was reading very carefully the memorials. That yesterday I was reading them until 2 o'clock a.m. Because I wanted to see the written submissions of the two main teams. And I'm of the view that a lot of efforts were put in your preparation. I was admiring not only the efforts, but all the references made to literature, to conventions, to case law. Of course, when we had our deliberations in the deliberation room, we were going through the performance of every one of you. But we have decided to make it general, to make a general assessment. If any one of you is in particular interested about the views that differ from judge to judge about the performance of, because we're different people, having slightly maybe kind of a variation of criteria, but we were unanimous that of course we have to take a difficult decision, that one of the two teams has to be pronounced the winner in this competition and to present our country during the April Jessup finals in Washington, D.C. Of course, I do not have much to add to the comments made by my sister and my brother judges. Of course, I would give an advice that those of you that yesterday were not praised as the two final competing teams shouldn't lose motivation to proceed further on, because quite often I would like to say that efforts are never in vain because they bring more knowledge to the person in question, regardless of the final result. Not that this means that we shouldn't be striving to achieve the goal of our efforts, but still at the end of the day, the richness is in the knowledge that we have acquired. I would suggest that during the presentation in Washington, those who are going to be pronounced winners have to be self-confident, to be concise, to the point, to be able to quite quickly understand the question posed to them and to straight go to the point without losing time in too much explanatory comments. I do not have much to say. If my colleagues wouldn't like to compliment the comments that I made, now I'm facing the honorable task and difficult at the same time to say that we have decided unanimously that the winner in the Jessup 2014 Bulgarian competition will be the team of the applicant. The applicant should be graded one of the best presenters in Washington. Congratulations.
As you all know, the Bulgarian national anthem Jessup is called after his name, and he will give the cup to the winners.
My dear friends, my students, my colleagues, I'm so now taken by you, because 10 years ago I was here, and on 18 years we went to the United States, but we were some small group here, 5, 6, 8, 10. I see here now, I'm so, I have never thought that this day will be the great day for all of us. These two boys, they're my friends. I think that without the Mitko, my friend, I would not be here. And I cannot say today that this small and country is very, very important, very big one. I have been in meetings of like this. They were also small. You know, I like you very much. And if I use this thing, I would say, if you could agree, when I went for the first time 8 years ago, we were in a small group. And then, in order to make all the group, the small group, I was the so-called Coach Smart Alex. That was my name, and I was very happy with this name, and still going there. In Bulgarian, it is Ostroumen Uchitel Alexander. You know that. But I think that I wanted to make all this small group of 4 or 5 to be very open. So I decided to give a name of everyone a different. And you will be seeing now that the first one was Rumiana. Rumiana was the younger girl, and we call it in Bulgarian, we call Kakarumi. This girl now is one of us, and she is a member of the International the Organization of the United Nations. And she is now with the James Crawford of the University of Cambridge in London. And she's always with us. She's my student. The second one was another student. Her name was Greta. Very nice girl. And I could give her the name Greta Garbo or Gabro, because she was from Gabro. And this young lady is now in a very important position in the Bulgarian Ministry for Foreign Affairs. And then another student, which from Burgas, I'm from Burgas. You should know this. And I give her a name, Mona Lisa. Why called Mona Lisa? Because she was looking in this way as if she was Mona Lisa. Now Mona Lisa is in Belgium. Is doing so. And we had one boy, very important boy. Like for instance today. I told them before that they will do it. And this, I give him his name in Bulgarian, Don Denko od Danachny. A member who was very active. Now he is in a special meeting of work in Moscow, and it's very important. Why I say all this? Because I saw you, and you will do it, and you could do it more than I was thinking before. So I should not speak anymore. I like very much to speak. And would like to you, my dear, please take it with strength. This is you were dearly precious. Please go here, my dear.
Sometimes get forgotten, and that we sometimes take for granted. These are Mitchell, Oleg, Stanka, Alexander, and everybody who participated in the organization of this event. You did a perfect job, and I was really happy to participate in this competition organized by you. Thank you very much.